Good morning, councilors. Thanks for the opportunity to speak. I've spoken before, many of you before, and there are 3 new councilors. I just wanted to say to the 3 new councilors, thanks very much for being here. And to let the 3 new councilors know, and perhaps the audience as well, is that as chair of the Fatherhood Coalition, we've been coming to the hearings for just over 2 years. And for the last year or so, we've been submitting questionnaires to all the judicial nominees to see if we can get some of the issues that we consider important addressed by the judicial nominees that are coming before the council. I'm very pleased to say, and I thank the today's nominee, Fernandez Duffley, very much for being the first nominee to respond to our questionnaire. We very much appreciate her doing that, and we hope it's a sign of things to come where nominees will respond to more the idea that there should be openness and transparency in the hearings. And so we thank the nominee very much for doing that. That being said, we have some issues still with the answers that the nominee provided on the questionnaire. And I'm going to read, when we get the questionnaire, we submit it to, and we send it out to a lot of our membership, and we get responses from the membership to the questionnaire. So I'm going to read one response we got, and it'll give you an idea of what many members thought when they read the questionnaire. And it addresses the answer specifically and generally as to what we feel is a major problem with the abuse of the 209A abuse restraining law. So this is from one of our members. His name is Roger Knight. It's interesting that a judicial candidate responded to your questionnaire. There is a depressing sameness to almost all of these judges, not just in Massachusetts, but all around the nation. She correctly answers the question about statutory authority, and however intentional or unintentional, she identifies where the statute has room for improvement. Defining abuse as placing another in fear of imminent serious physical harm sounds good in theory, but we all know what it is in practice, which is, quote, raising your voice and sounding irritated. Every married couple in history of the human race could have a restraining order based on that standard. The practice is that idleness of the threats are never taken into account in these restraining order hearings. Angry people often say things like, I'm going to kill you, quote unquote, when they have no intention of committing murder, and no one else, including the target of such anger, takes it seriously. We have now created a legal climate where people have to walk on eggshells on a 24-hour, 7-day-a-week, 365-day basis, lest they say something that could be a basis for a life-ruining restraining order where there is no jury to make the findings of fact. And I'll just interject here, when we say life-ruining, we mean a man is given, mostly men, are given 15 minutes to pack up their belongings and leave their family home and leave their children and be faced with financial ruin in many cases for what's happening because of an accusation. Quote, I did not, while sitting on a judge on the Probate and Family Court, issue 209A orders which did not meet the requisite standard in order to be, quote, on the safe side. Of course she didn't. As explained here and above, the requisite standard effectively includes raising your voice and sounding irritated. In other words, almost anything can be considered a violation of a restraining order, or an accusation can be taken as that, because they would place any irrational person in fear of imminent serious physical harm, quote unquote. On the issue of findings of fact, here is a revealing answer. Findings would not necessarily be helpful in a case where the factual basis is also set forth in the affidavit and is determined by the judge to be credible, end quote. And that is the crux of the whole restraining order problem. The judges are the sole triers of fact. We all know that while they profess impartiality, when given a case where the petitioner sets forth under penalty of perjury that the respondent made threats, and she is now afraid of him, and the respondent testifies in person or even in his written response under penalty of perjury that he did not, and no other evidence is available, that the judge will almost always find her testimony credible and his contradicting testimony not credible. One of them is committing perjury, but of course no perjury charge is to be had. Of all things the English have done, the jury system is one of the things they did right, is the one thing they did right.
A jury of your peers will understand that whatever they do to you cannot be done to themselves. Can be done to themselves, I'm sorry. A judge is not your peer. She is a creature of the state. She may claim impartiality, but she will serve the interests of the state. In this case, the interest of the state is to appear to be doing something about the scourge of domestic violence, no matter how wrong the solutions are in practice. On that basis, we must remember this rule of thumb. The primary interest of government is to expand itself at the expense of everything else in society. Until you understand that, nothing government does makes sense. When you understand that, everything government does makes sense. Now, there's, of course, some generalized statements there, but I think a lot of people, especially men and fathers, are feeling this in the way they're treated by the courts. And as I said, we appreciate the first step that was taken by the nominee to respond to the questions, and we hope that that will be something that's carried forth in the future as well. It is a major problem, as I've been saying for the last 2 years. There are many, many people who are outside of this room of basically lawyers and judges and legal industry personnel who do not see the world the same way as most people in this room see the world. And I hope that the council will take this into account when reviewing this nominee, who I must say seems like a very nice person, and personally I'm sure she is a very good person, but there are some questions about her outlook on how she'll handle cases that will affect men and fathers in the court, particularly when it comes to custody matters and things that come up from the probate and family court. Thanks very much. Yes.
Thank you, Joe, for coming, and I want to commend you because you and Patrick are continually coming from your work to do this, to come to our hearings, are the voice for fathers. And I know one judicial nominee recently, a man, attorney going for a judicial appointment, was very candid, and he told me that many lawyers tell their women client to ask for a restraining order when it doesn't apply, and, you know, as you said, for frivolous reasons, you know. But
if I may, counsel, just interject for a moment. We, and in the past, as you know, other counselors that have been here have mentioned that it's a legislative matters as well. We will be introducing changes to the legislation. We hope that will move forward this session. But at the same time, we think the judges do have a role currently to play in the existing law. Just to give you one example, we were recently in a court as a court watcher for somebody who was in the probate and family court on a matter. A restraining order issue came up. The judge asked the lawyer for the person who brought the restraining order, why do you want to extend it? The lawyer hesitated, and the judge quickly said, you want it extended on the same basis as it was originally issued. Isn't that correct, counselor? And the lawyer quickly picked up on the helpful hint, and the lawyer said yes, and the judge said extended for another year. No evidence was presented at all that this order should be extended. So that's the kind of conveyor belt mentality that's in the courts right now for restraining orders, and it needs to be changed.
Right. Well, I did want to say that, you know, I have been supportive of the Fathers Coalition. I really believe every child should have the same relationship with mother and father, in any, if it's all possible, to have joint custody. And I do want to commend the nominee for answering that questionnaire, because you have been given very I have to say lame excuses for not answering the questionnaire. And you know, and I've been asked, I've urged every candidate to do that, and this candidate is the first. So I think that it should be said twice. You said it and I've said it, that she did answer the questionnaire, and it's not a few questions. What is it, 25 or?
Oh, this one had 15.
Or 15. So that's a lot of time to put into that, and I thank you for doing that, and I thank you for coming and being the voice for fathers, and I think you know, this is your forum to have the judges and the lawyers and everyone that come to these hearings to hear what fathers are facing. And so I think there's still an inequity, and I hope that, you know, that with further legislation we can, you know, we can see some of these fathers, and I've said it before, one of the fathers I talked to hasn't seen his daughter in 8 years. She's 9 years old, and he's a good person.
It's a very common occurrence, unfortunately.
I know.
Yes,
and it's not fair. It's not fair to the child. It's not fair to the father. So I thank you for taking the time and coming.
It's my pleasure. Thank you very much.
Lieutenant.
Council, I know,
one quick question, Joe. You mentioned a lot of the 209As. Does the Fatherhood Coalition have an opinion as to what their thoughts are with respect to Judge Duffley's decisions, I should say, if the Fathers Coalition is even aware of it, on the removal statute and the cases that she's decided with respect to removal?
We do.
Out of the Commonwealth.
Yes, we do, and Pat McCabe will be speaking to that specifically when he addresses the council. I believe he's the next on the list.
Okay, thank you. Good to see you again.
Good to see you.
I have a question. You
Consultation?
testified about the restraining orders and the abuses in the system with respect to those and divorces and probate matters. And I know that there is a school of thought out there, I'm not sure what the legislation is that your group is proposing, to give the probate court exclusive jurisdiction over restraining orders because of the unique insight that most probate judges have with respect to restraining orders, and when one of the parties may be going out to gain an advantage, for example, in a divorce, go out and get a restraining order, get custody, get exclusive use and occupancy. So I know that that is something that is a problem as an attorney who practices in the probate court quite a bit. So I'm not sure if that's something that your group is looking at for legislation, but from where I come from, it would seem that a probate court judge would be uniquely qualified to identify when an abuse is underway, and perhaps on the highest court in the state could bring some insight with respect to family law when it comes to 209As. So,
Yes, there was some discussion about having the legislation target one type of court. I'm not sure if it's the probate court, but to limit the venue for it. That's not in the bill that we're submitting officially. I think we're concerned, and I think the crux of the problem is the legislation is written so broadly that, as this one of our members pointed out, that anything that verges on normal human behavior can be taken as an act of, quote, violence or abuse. And so our legislation, we frankly think the 209A law should not even be in effect, because we think that assault and battery laws should be on the way these problems are handled. But we do think that in changing the 209A law to take out the word fear and actually substitute that with threatening somebody with physical harm is the way to go with the existing law, in addition to some other changes.
thank you.
If I may.
Sure.
I've handled a fair number of 209A cases over the years, defending them, mostly representing men, frankly, some occasionally women. And I appreciate what you're saying about the abuse of the process. There's no question anybody who's out there practicing sees that on a daily basis, where restraining orders are issued on what I'll describe as tenuous grounds. The bill that you're filing, does that change the standard for the issuance of the order?
It would remove the fear category. Instead of someone just simply saying, I'm afraid, it would change it to actually threatening somebody with physical harm. And that would be a major change in our opinion. We still think that the existing assault and battery laws should be long. The premise behind the 209A law is it's sort of, if you ever saw that movie Minority Report with Tom Cruise, where the crime has not yet been committed yet. This is supposed to protect somebody from crime that hasn't been committed yet. And so it's actually placing a guilty verdict on a person before any act occurs.
You would agree with me that appellate decisions over the last couple of years have chastised judges for issuing them too frequently and
Yes, I would.
and on tenuous
Yeah.
grounds.
Yeah. The workers are not doing what the upper echelon is telling them to do. Sure.
Thank you.
Okay. Thank you.
Thank you. Patrick McCabe?